All right. Good afternoon, everyone. Welcome to another edition of Fire Law Vlog. And this is what was supposed to be our first of the weekly Fire Law Vlog episodes. Let me just stop that from giving me feedback.
You
And
remembered. You remembered
I
it this
remembered. I
time.
remembered. But this was going to be the
Getting better.
first one with Brad Pinsky, where we're doing a sort of a weekly review of the cases that happened last week. And as it turns out, Brad went to some undisclosed location in the Caribbean. And even though he's in a five-star hotel, it does not have the kind of internet that would allow him to participate in the kind of video conference that we're doing. So Bill Macarone has agreed to sort of fill in. And thank Bill, thank you for filling in. And I have a feeling you're going to be a regular on here anyway, but
No problem.
yeah. So, but the goal of this is to kind of person to person discuss the cases that have happened in the last week. And I cover them in my blog. We usually limited to about 5, sometimes 6 cases in a week. But there's an awful lot more that happen out there that we can't cover. So with that, Bill, I know I sent you, the sort of an advanced copy of my newsletter that has the 5 cases, but then has a listing of some of the other cases, and maybe there's other cases that you came across as well. But which of the cases from last week really kind of stands out to you?
Well, I was just going through them this morning, and one of the ones that jumped out at me is it's a state court decision out of Illinois regarding some disability benefits for Chicago firefighters, and it was just interesting to see the court's take on exactly what the benefit that they received, or the entitlement they received under the local statute, under local ordinances there. And basically, in a nutshell, without getting too deep into it, if you're disabled from the Chicago Fire Department after an on-the-job type of injury, you and your family are entitled to health care as a benefit going forward under local statute there, under state statute, city of Chicago ordinance, et cetera. And what occurred was, when these retirees, this disabled retirees, get to Medicare eligibility, which I think around age 65, that you kind of roll over onto Medicare. Medicare. You lose the city basically reeled back the coverage and said, listen, now you're eligible for Medicare, and therefore you're no longer going to get the benefit of the city. They sued, and actually the lower court found for the city, and then the appellate court basically affirmed that and said, listen, the lower court was correct in determining that the way the statute is written, they were not entitled to lifetime healthcare benefits, even though they were disabled, even though they met all the requirements. But at some point, they dropped off that. They dropped off, that benefit dropped off. And what was interesting to me in the read was that nowhere in the ordinance or in the regulations did it state that was the case. And I think that was one thing that was unique. And I can understand both sides of the argument. This, a benefit like that and maybe cannot go on, for forever. I can certainly understand that aspect of it, but also at the same time, nowhere did it say that it would expire, so to speak, or cease to cover the firefighters once they reach that age. And one thing that I was looking at was under the court's reasoning here, in my opinion, at any time that the firefighters were eligible for any other medical benefits, would it have ceased at that time? And I don't know if you had a chance to kind of look through it, Kurt, but I think
I
that
did.
was
I
one
read
of
the case. Yeah.
and that was one of the things that I kind of was struggling with, and that I could understand. I can see where the city's coming from on this, and the cost must be tremendous, et cetera. But at the same time, it seems as if the court, in my opinion, kind of read that pretty broadly. I don't know how your take of it
Yeah,
was.
I mean, I'm personally involved, not in a litigation, but as a retired Providence firefighter, I was told when I was hired that we had lifetime. Once you reach retirement age, it's healthcare coverage for life. And then the city went back because they were in financial trouble. They went back and said, well, this is what we need. We need you to go into Medicare, and then we'll provide the coverage over Medicare. And that apparently there was some litigation that some of the members brought, and the union settled. And when the dust settled, the city ended up in a position where they could provide coverage over Medicare, but once you turn 65, you have to go on Medicare, which, sounds good. That sounds pretty reasonable. Okay. With the exception now that Medicare is not free. Somebody has to pay for it. And right now, and I'm not complaining, but it's just a reality of life that I'm up to somewhere around $475 a month for Medicare, $100 and something a month for my copay for my coverage that goes over and above Medicare that the city is covering. So somewhere around $600 a month now is going out the door. Which, in the big picture, if I was a carpenter or a plumber or an attorney and I was paying for my own health care, it's cheaper. But my point being, I have a lot of sympathy for the Chicago firefighters who brought the litigation. I also have sympathy for the city in terms of the cost of policies today versus when I was hired in 1979, healthcare was not as expensive as it is today. So both sides. I really thought the court stretched to reach the result that they maybe perhaps wanted to get to protect the city.
Absolutely. And you have to wonder too. I mean, I suppose many of these recipients, when you think about it, that are receiving this benefit now, would they qualify for Medicare because they're totally disabled before they reach that age 65, right? I mean, because there is an aspect there. I think that's Medicare, Medicaid. So you have to wonder. That doesn't seem like a big reach based upon what the court said, and that's certainly not, I don't think, the intent behind the law, right? I mean, that to me was the difficult part.
These are tough, and I couldn't find any articles on this ruling, so we can't give you a link to a news article or anything. But what I will do is in the description of the the video here, I'll provide a link to the actual case, and folks who are interested can read it, and it might be something that you want to archive for posterity. Download a copy of the case just in case you need it, but depending on which side of the equation that you're on. So yeah, that was one. And I remember looking at it last week as I was going through my cases to blog about, and I said, how do I blog about this in 3 or 4 paragraphs, 5 or 6 paragraphs? It's just too much. And then my own personal opinion, I said, all right, I'm not going to do, I got another good case tonight. I'll blog about that. And so I didn't really cover that one. So that one's not in my blog, but it is in the newsletter. If you get my newsletter, there's a link to the case, and I'll put that link in the description to this video as well. Yeah, that was a good one. I think there's a number of them that stood out in the last week to me, and the first one I want to sort of bring to everyone's attention, because it's something that we haven't seen to date. This is the first time, was a successful challenge to a vaccine mandate. I'm successful to some extent. I mean, but I've got, I should have run the numbers before, but it's somewhere around 37, 38 cases in my database where firefighters are challenging vaccine mandates. Prior to the St. Paul decision last week, 0 victories. Okay. St. Paul firefighters got a sort of a victory. They got a temporary restraining order, temporary restraining order. It was a preliminary injunction or temporary restraining order. It was a temporary restraining order against the implementation of their vaccine mandate. But the legal theory, there's so many different legal theories that have been thrown around to challenge the vaccine mandates. You have First Amendment issues, you got, religious discrimination issues, you got race discrimination, you got personal privacy, the integrity, bodily integrity embodied in the due process clause of the 14th Amendment, right? This one was on collective bargaining. And essentially that it said was the vaccine mandate is a change to the terms and conditions of employment of St. Paul firefighters, and the city didn't bargain it. They unilaterally implemented it. And the court agreed, not that the union's going to win and can block it totally, but that they gave them a temporary restraining order and said, go to your respective corners and come out and negotiate a solution. So interesting decision that came down last week out of, let me see what court that was, the Ramsey County District Court. Yeah, so interesting. What's your next one, Bill?
Well, I was also, I was struck, one of the ones that were cases that you discussed, or at least a lawsuit that's coming that you discussed on the Beyond the Blog portion of your newsletter, was the Orange County case of the discrimination out of Orange County, California, discrimination lawsuit coming out of there, out of the public information officer. It was a female brought in to the department. According to the article, she was brought into the department, so she really didn't kind of come up through the ranks. And it certainly appears, at least based upon the, there's nothing from the fire department yet as far as the defense is concerned, but at least for her claims that she's making in regards to how she was treated by the fellow firefighters, it certainly seems like there could be some issues coming out of Orange County in the next few months or years. Basically just a repeated pattern of abuse and discrimination based upon her gender. At least according to her allegations. Again, that's one side of the story. There's much more to come, I'm sure. But it's certainly, according to the article and according to what her claims are, it seems as if trying to take a 30,000-foot view of the situation. It seems as if some folks weren't too happy, maybe that someone came in from the outside and was kind of put in that type of a position as the public information officer. But I thought that was interesting, and it's funny. It's you see those kind of allegations, and you think these are the kind of allegations that you almost were commonplace 30 years ago or 40 years ago, and then sometimes you say, oh, maybe they're not so uncommon today. We still have some work to do there. And again, not passing judgment. We have to wait and see how this shakes out. This is simply the first. The first shot, so to speak, with her, filing this complaint. But I did find that was, on one hand, sad potentially, that we're in this situation still today.
Yeah.
So
yeah,
we'll have
and
to see where that goes.
Yeah, and it's so hard to, especially from 1,000, 3,000 miles away, to know what it's so hard, because sometimes you have somebody who maybe they are being treated differently, but it's because they came from the outside. It's got nothing to do with their gender or whatever. But they're able to create a case that makes it appear that it was because of their gender, and out of convenience. And who knows? But we see, it's certainly not an uncommon fact pattern that we see. So. One of the cases Brad was took an interest in, and I think he was going to talk about, was the Ohio case. It involved a fire department that responded to a fire, and the fire investigator came in, and a little bit like the facts are not fully explained, but the bottom line is, fire investigator comes in. Comes upon some drugs, some weapons, some drug paraphernalia, calls in the police. The police then conduct an investigation, and they charge the homeowner with drug possession, firearms violations, and different things. The woman who owned the home, let me see here, her name was, where is it? Just so I get it right. No, we don't even have her name here. Well, boy, I might have to go to the actual case. Holmes, Nicole Holmes, yeah. And so she was the homeowner. So she filed a motion to suppress. And this is on a criminal case. She's charged criminally with drug possession, drug paraphernalia, firearms, and so on. She's claiming that the police violated her Fourth Amendment right. Fourth Amendment being, you've got to have a search warrant to come into someone's home and search it. So she moved to have the evidence against her suppressed. And if she's successful in that, the prosecution may not have a case, so the charges would be dismissed. So she filed the motion. The trial court agreed and said the police should have got a search warrant. The fire investigator was legally in there, but once the fire investigator called the police in, you should have got a search warrant. And so the prosecution, the state, appealed it up to the Court of Appeals, and the Court of Appeals reversed, and rightfully so. And the court did a really good job. In fact, Brad was saying that this is a perfect case for anyone who wants to teach basic search and seizure law for fire investigators. The court does a very good job of running through the different cases, as Michigan versus Tyler, Michigan versus Clifford, all those cases we studied in law school and in other types of classes that we've attended. But the bottom line is the Fourth Amendment is a very strong protection for people to prevent government from going in their homes. There are very narrow exceptions, but one of them is an exigency. And when there is an exigency, such as a fire in someone's home that justifies the fire department going in, you don't need a search warrant before we go in to put the fire out. Once we're there, we can remain there for a reasonable period of time to conduct a cause and origin investigation. If during the cause and origin investigation we uncover evidence of criminal activity, whether it's related to the arson or maybe it's unrelated to the arson. I think this is where the judge got kind of hung up. The judge at the trial court got hung up because he said, well, wait a minute, you're doing a cause and origin, but you found drugs. So you should have went and got a search warrant to continue the investigation to drugs. And it was really an extension of two things: the exigent circumstances and the plain view doctrine. Because once you're there legally, anything that's in plain view is fair game. And the principle being, once the investigator is there, the investigator being a representative of quote unquote government, it's no greater intrusion into the person's Fourth Amendment rights for the investigator to call in another investigator, that being, instead of a fire investigator, being a police investigator. And then for that police investigator then to call in a detective or a crime scene technician to process the evidence. So really good decision. If you're concerned about Fourth Amendment issues in fire scene search issues, but I thought that was an excellent case, and I'm pretty sure Brad was going to. Brad took an interest in that before he went dark and, got outside the technology bubble of the United States. And
that poor guy, on a beach right now drinking with an umbrella.
I know. It's sad, but somebody's got to go down there and, despite the COVID, I'm sure he's getting a good deal. So.
I got one more if you want. I also the case out of Louisiana with the gentleman that signed himself out AMA about 20 minutes after getting dropped off. When you look at the facts are pretty much involved, as far as it appears as if I think the individual was arrested, at least in charge with DUI, spent the night in jail, got out the next day. I guess on his way out, within a few hours, he got picked up on the side of the road where he apparently was or supposedly intoxicated or under the influence of drugs of some sort.
Or both.
Yeah, they scooped him up. The paramedics scooped him up, brought him into the hospital, dropped him off, and he signed himself out literally, I think it was 20 or 21 minutes later or something like that, AMA, and he left. So the lawsuit, well, then he left, and then he proceeded to get hit by a vehicle, high speed, terrible accident, and suffered some severe injuries. And the lawsuit is basically alleging that the medics, because of the the St. Tammany Parish Fire Protection District, their process of getting the way I read it, their process of getting the report to the ER after the medics dropped the person off is via fax. And that is a slower, that's a slower way to process that information or to pass that information along. And because of the time delay in the way that report was sent into the hospital, that didn't alert, and the medics didn't alert the folks that were working in the ER that this person was potentially under the influence or was going to harm himself or do something, unable to care for himself. And as a result of these two factors, that's why the individual got severely injured. So that was it was an interesting read, to say the least. And you can't help but feel bad for the poor. I mean, he's suffered some serious, significant injuries, but at the same time, I'm sure that those medics are, changing patients over at an incredible rate, and and if the report got there a half hour later, I don't think that I being in the service, you see that revolving door of the emergency room, and it's frustrating at times, to say the least. And
It is, and it's not just that the medics might have been real quick in their delivery of of the patient. It's possible that the ER staff was just too busy, and you've been sitting in the emergency room, and you're waiting, and you hear baby choking, man down, and like, we've got to get back and handle the rest of our business. You're busy here, we're busy out there. So it's not just on the EMS side. The hospital staff bears some responsibility, and I guess maybe that kind of my take on this is I don't understand why this gentleman who was badly injured didn't go after the hospital. Like, why is it the paramedics' responsibility to diagnose this man's psychological problems in the street, okay, when the hospital has them in nice bright lights and all the accoutrements that you have in an emergency room compared to on the side of a road where you find the guy? How are the paramedics somehow specially qualified to evaluate his psychological condition when the folks at the hospital were not able to? And I don't know. I mean, there's probably more. When I first read this, I started with the headline, "You can't make this stuff up. Man blames fire department." And then I started reading it, and I said, there is some parts of this that are, legitimate. Like, when we have the technology to transmit a patient care report electronically immediately, should we be doing it? And should we be sharing? Is a delay of an hour? And the allegation here is that the fire department took about an hour to fax the patient care report to the hospital. By that point, the man had already signed himself out. And I'm sure the hospital is saying, well, if we had only known, well, that, and like you said, I mean, that should have been exchanged. I got to believe it was exchanged. The information was exchanged. Whether the person at the hospital was actually paying attention or dealing with something else and going, yeah, fine, we'll get to him, and they're doing what they're doing. So, at any rate, interesting case, and I think that's why I wanted to do this video series, where we can get into a little bit more detail on some of these issues. And to me, what this case stands for is maybe just an exclamation point on our medics, but also our hospital staff, that exchange is important. And from the medic side of the equation, did we pass on the information we needed to? Okay, not because of a lawsuit, but because the man was very seriously injured, unnecessarily, perhaps. Okay, did we pass on the information? So that part number one, and number two, can we prove it? Okay, can we prove that we pass it along? If we gave them the patient care report, and there's a little bit more in this case. The man was apparently from Missouri. He came to Louisiana because his girlfriend's father passed away, I think, or something to that effect. Yeah. And he was despondent over that. Yeah. He got caught drunk driving. He was despondent over that. He was apparently suicidal, whether the medics knew it or didn't know it. But he was having some psychological issues. And the hospital, I'm assuming the hospital was not.
Yeah. So, and I imagine the jail, if they released them too from the jail, you would think that he would, that at least, but again, it's,
Well, another part, and somebody commented on this case. I don't know if it was in Facebook or LinkedIn, but they asked about the coroner, because apparently, if you read the decision, the coroner in Louisiana has the ability to make the hold, to put a hold on someone, a psychological hold on someone in the hospital, have them committed, I guess maybe a better way. And the point was, why would a coroner be involved? And I see. So I'll give you the answer. But what do you suppose? Why do you suppose the coroner has that responsibility?
Because they make the notification to next of kin very often. I'm assuming that there's, that they're in the same, they have, whether it's at the at the morgue. You know, there could be family there to identify a victim
And
or
so
something.
I had to get into Black's Law Dictionary to look up the
Well, it's
definition of
Louisiana
coroner.
too. It's
Well, it
Louisiana
is.
too,
No, you're
so
right. You're right. And for those of you who aren't
different.
familiar, Louisiana is the only what we call civil law state.
Yeah.
Louisiana has its connections to France, and France is a civil law state.
Yeah.
And the rest of the United States is what we call a common law state. And you know, that's we don't even want to get into that little bit there. But the point being, and I wasn't aware of this, I assumed, like you assumed, that a coroner, and the person who commented on this assume a coroner, their job is to deal with a death determination. And in many jurisdictions, that is not a coroner's responsibility. A coroner is a judicial official. So Article 3, think Article 3 type of person. It's a judicial official. In some jurisdictions, that judicial responsibility has to do with cause of death. But in other places, they have broader judicial responsibilities, including the civil commitment of people.
Wow.
And yeah, so it was a little bit of an education for me on that. So I thought that was interesting. And again, I assume a coroner is like this medical examiner. What's the difference? And it's
nobody leaves. Nobody can leave once they got them. But yeah,
I guess there's a certain personality type, I guess, that goes into you know, that profession. They don't have to deal with people. So
that is
right?
interesting.
So, but yeah, so at any rate, so, all right. So we've been going here for about 25 minutes. So we're gonna kind of wrap it up. Only because we want to keep these brief. We don't want to drag them on for an hour, 45 minutes. We really like to keep them to 20 minutes. So, but I do want to make a couple of requests for folks that are listening. If you're not already subscribed, please subscribe. And what that'll do is it'll send you an email whenever we're going to go live. And usually our goal now is to do these Mondays at 1 o'clock Eastern. And so you'll be able to watch the recording if you miss the original. But please subscribe. It helps us. And if you like it, like it. If you don't, well. If you don't, well, I guess go ahead and unlike it, but we hope you'll like it. And, you know, certainly we're welcome to feedback that folks may have. So, all right. And that's going to do it for another.